Welcome to Secure Your Creation podcast with Mario Milano. We're here today to dispel some myths, Mario. How do you feel about that?
Yeah, always happy to set people on the right path as far as intellectual property is concerned.
Bingo. So, myths happen a lot because people really don't have a full understanding of the details that come with, in this case, we're going to talk about patents. So, I'm going to start right from the door with the top myth that we've heard, which is you need a prototype to get a patent. Tell me your viewpoint on that.
Yeah, it's common for people to have a misconception about that. There's so much information available these days, and we just don't know what's good information and what's not. So, I'm here to tell you that you don't need a prototype to get a patent on your invention. Some people do elect to build the prototype and have a working model. That way, they can work through any issues that might come up. They can figure out any alternative designs that might work as they're working on their prototype, but it's certainly not required to have a prototype. Some people will just patent it when they've thought of the concept. They think through how their prototype could work or how the invention could be made and some different ways that it could be made. And we just file those as the patent application. You can imagine that for some of these really big, complicated, expensive patents, that it's just not feasible to go through all that work to build a prototype and then learn later that you're not even able to secure a patent on it. So instead, what they'll do is think through it, have it designed conceptually, either with a computer program or they can just draw things out. And then once all that's completed, we'll get the patent application on file. Once they get it approved for their patent, now they can go out and build the prototype. And sometimes having the patent on the concept can even help them secure funds for building the prototype.
Awesome. Awesome. So, you ready for number two?
Yep.
Okay. Number two is now that I've went through all that and I have the patent, it guarantees me business success.
I wish that was true. And a lot of my clients wish that was true as well. Sometimes, you get a patent and for whatever reason, it's just not commercially successful. Some of the things that I see on that are it's too expensive to make. You can think for small consumer products, the having it cost an extra couple dollars can be the difference between commercial and success and the product struggling. Other times, the market moves. Maybe somebody else came out with something different and people are moving away from that. You can imagine that when they were still improving upon VHS players when DVDs became popular. So even though you got a patent on that VHS player, it's not going to be successful because everybody moved to a DVD player. And so it would be nice if that was the case, but no, getting a patent does not guarantee commercial success.
That's a shame because everybody would have patents, right? Then you would be very busy. So, in terms of number three, my invention isn't very complex, so I don't really need a patent, right?
Yeah, that's what some people think, that you have to have this big groundbreaking idea in order to get a patent, but that's not the case. It typically, what I see from large companies are they're making small improvements to their products over time. Sure, sometimes they come up with a brand new platform for a product, and we're going to get multiple patents on that product, and it's all going to be groundbreaking territory. But a lot of the patents that I prepare are small improvements on existing products. You can get a patent on the whole car, but you can also just get a patent on the new rear view mirror if you want.
I like the way you broke that down. It's very simplistic. It was awesome. So now that I have a patent, I'm protected, right? Nobody can touch me. Is that 100% true?
No, unfortunately. And that's something that we try to educate clients on, is that, just because you got a patent on your product doesn't mean that if you were to make that product, you wouldn't be infringing the patent rights of others. Because like we just mentioned, you can get a patent on small improvements in existing products. Well, there might already be a patent on that existing product. So even though now you came out with your product that has this new feature, you could still be infringing somebody else's patent. Also, you get your patent and you want to be protected as far as nobody stealing your idea. Well, they could also try to design around, basically use the same features that you have in your patent without actually infringing your patent. So, that's something that we would consider and try to make sure that we get appropriate patent scope so that it's very difficult for somebody to design around it.
And number five, the common myth is I have a patent. I had a patent back in 1942. Is that still good for today?
It would be good to hang it up on the wall, but it's not going to give you any enforceable rights today. Patents in the US, patents are good for 20 years from the date of application, with some exceptions, of course, but typically it's 20 years from the date that you filed your application. And there's no way to really to extend that. So once the 20 years is up, then that's it. The USPTO thinks they want to encourage you to publicly disclose your ideas by filing a patent application and teaching everybody how to make and use your invention so that it improves society as a whole by spreading knowledge. And in exchange, you get a patent, you get a legal monopoly on your idea for 20 years. And they think that 20 years is the right scope for you to have that monopoly. And then it's just publicly available.
So then from that point on, you can just repatent it again if that 20-year span ended?
Not really. You wouldn't be able to patent the same concept because now that would be considered prior art. And so if you tried to refile the same thing, they would look at your patent and say, you can't get a patent because you already had one. But if you made any improvements, then, we could patent those.
So it would seem to me, next myth, that would be logical here is that I have an idea. So if I patent the idea, I can get it before anybody really gets going on it, correct?
Sometimes, yes. So it's tricky when you say you just have an idea. Mental processes are not patentable under USPTO rules. So if it's something that you could just perform within your head, if it was a math equation that you could perform in your head, then that's not going to be patentable. But if you mean an idea, like you have a concept for a new product, then we can certainly get a patent on that because the patent is for the product itself and not just for the idea.
So in terms of coverage, you keep mentioning about how in the U.S. patent law, or whatever the case may be, you're telling me that my patent isn't covered worldwide. Somebody in a whole other country could take my patent or take my idea.
Yeah, unfortunately, you get a patent in the U.S. that covers you in the U.S., but that's it. It won't have any effect on any other countries. So a lot of times, clients will look to expand to Europe, Japan, China, Canada. Those are typically the large markets that I see. Australia as well. But if you want to get patent coverage, you would have to go through basically the same process of obtaining a patent in those other countries as you would here in the U.S. Now, it's a little bit cheaper if you file one application in the U.S., then you can take that application and file in all those other countries simultaneously using what's called a PCT application. And the benefit of that is, you only have to pay one attorney to prepare the application for you. And then, I offer where, I'm the point of contact for my clients, where I interact with counsel in those other countries where they want to file their application to get another patent, and make sure that we have consistent claim scope, that we're covering the commercial product, and that they will successfully obtain a patent, hopefully.
So let's talk a little bit more specifically to your specialty. So I know that you like medical devices, some wheelchair, hospital type stuff. Tell me something in reference to patents that might be a myth within specifically those industries.
Yeah. So sometimes I hear people say that, oh, well, if I get a patent on it, then FDA approval will be easier, particularly for these medical devices. The USPTO and the FDA are separate bodies. The USPTO will handle patent applications and granting patents and things of that nature. The FDA oversees medical devices, and they don't really interact with each other. So if you get a patent, that doesn't mean that you're going to be able to get FDA approval for your medical devices. The time that they do kind of overlap is when you want to list medical devices in the Orange Book, which is, saying that it applies to a drug. Then there's some interaction there, but that's about it.
So in terms of patents, are there other things that may be myths that we didn't cover that maybe come to top of mind from you?
Yeah. So a lot of times I hear people think that, oh, well, I had the idea first, so I should be able to get a patent on that. A while ago, well, not that long ago, in a couple years ago, the U.S. switched over. It used to be first to invent system, meaning that as long as you had your notes showing when you conceptualized your idea and you were working diligently the entire time until you filed your patent application, you could establish priority that way and say, even if somebody filed a patent application before you did, but you had this record that you came up with the idea first, then you would still be entitled to the patent. US was really the only system that did that. Other countries all had a first file system where just whoever files patent application first has priority. Now the US has moved over to that system. So, you can't sit on your idea anymore like you used to be able to and kind of keep improving and tinkering with it. Now, if you want to get a patent, it's best just to file it as soon as you can. The first to file system, I think it has its pros and cons. One of the benefits is that now we don't have to chase down inventors 10 years after the fact and try to establish when they actually came up with their idea. Now we just look to see, okay, this is when it was filed. We have more knowledge, especially when we're looking at other people's patents and we say, okay, this is their priority date. We don't have to wonder about, oh, well, it says that it was January 1st, 2021, but when did they actually come up with it? Now we know that, look, the filing date is the filing date.
Wow. So a couple more here before we close out. Patents are easy to obtain, right?
I see
a smile there. That made it a little sinister.
I wish it was, but at the same time, I wouldn't have as many. I might not have a job if it was too easy. So it can be complicated because when you start to see the prior art that's out there and knowing how to get around it and how to comply with the USPTO rules, even just their technical rules for how do you file the application, how do you respond when the examiner issues an office action. There's ways that has to be done. And if you don't do it correctly, you can correct them, but it's things that take time and effort. And it can be very complicated when you get an examiner who's rejected your application and now you have multiple prior art references that you have to navigate and still say how your invention is different from all those. That's where it can be very tricky.
So I have a doozy one here for you. Ready? You prepared for this one? You ready? Here we
Tell
go.
me.
So I don't need a lawyer to file a patent.
So the USPTO does allow patent agents who are not attorneys, but they have taken the patent bar with the USPTO, and they're engineers or scientists or people who have a technical background. So in that sense, they're not strictly attorneys because they haven't attended law school, they haven't taken a state bar exam, but they are still admitted to practice in front of the USPTO. Technically, you don't need a patent agent or a patent attorney to file your own application. But for a lot of times when I see somebody who gives me an application that they say, oh, I filed this myself, they didn't have to tell me that. I can already tell that they filed it, that they drafted it themselves and filed it because, it doesn't look like a patent application that came from an attorney. There's a certain way that the applications usually look. There's certain ways that it's written. The claims are usually the biggest giveaway because a patent attorney or a patent agent is going to draft it that we want to get you the broadest coverage that you can so that you're not just protecting what your immediate invention is, but you're trying to keep people as far away from that as you can. Typically, when I see inventors who haven't filed who aren't familiar with the patent application process, when I see applications that they've written, it's such a narrow claim that it's unlikely that anybody would ever infringe that claim because they're so specific in what they're saying.
That's big. And then ultimately, people get it done right the first time.
Yeah.
Because if it goes out right, what somebody did themselves and it's rejected, realistically, it could have been something minor that yourself would have picked up, I'm assuming.
Yeah, absolutely. Because you have to have support for any changes that you want to make to the application. And so sometimes, filing a patent application can be expensive. But whatever money an inventor saves by filing the application themselves, they usually end up having to spend on an attorney who then has to go back and try to fix whatever they filed and try to salvage a patent out of that. Even if you're saving, you're going to spend about the same amount of money, but the or more, by doing it that way. And the value of the patent would be much greater if you have it prepared professionally. Just like anything else, the people who do it all the time, they're experts at it, and they're going to know how to do things the right way. And sometimes doing it yourself is just not as good.
It's just another step and another cog in the wheel that doesn't need to be there.
Yeah.
Another one here is that you can file a patent anytime after inventing it.
So if you do not publicly disclose it and you keep the idea to yourself, then yes, you could file for the patent at any time. But once you start telling other people about it or writing about it online, then you're not going to be, you're going to be prevented from filing the patent application, because now your earlier public disclosure will be considered prior art against you. And so an examiner would just reject your application based on your disclosure of it.
Wow.
The other risk with waiting to file it is just, it gives other people time to come up with your idea as well. There's a lot of patent applications filed every year. So you never know. Sometimes we file an application and we find out later that somebody else filed a very similar patent application a month later. And so, when that's the case, it's like, you're very disappointed because the other side or whoever filed it later is very disappointed, because they could have had an application had they just been a little bit faster in either filing it or getting whatever materials together that they needed. It's a large price to pay for waiting.
And it's nothing worse than coming late to the dance.
Yes.
Nothing worse than coming late to the dance. So are all patents created equal? That's a myth.
Yeah, that is. And absolutely not. You can imagine that some of the most valuable patent applications, or at least the most litigated ones, I would think, were the sewing machine was a big one, the typewriter. Those are kind of very famous patents because they were so groundbreaking in their technology. Some patents are just small improvements, like we mentioned, and they have value. But when there's groundbreaking patents, they're certainly going to be worth a lot more.
So the other one here is, which I've even heard, and I'm not even in your space, is I can just ignore the patents of competitors. That doesn't mean anything.
Yeah, yeah. That's not a good approach to take. I call it the ostrich approach, where you just stick your head in the sand and hope everything works out for the best. That's not good. Eventually, if you start selling a product and you're ignoring the patent rights of others, and you intentionally just ignore them and don't try to look out for them at all, number one, if your product is successful, somebody's going to end up sending you a cease and desist letter, or they're going to end up filing a lawsuit against you for patent infringement. And if you're intentionally ignoring the rights of others, then that's what's considered willful infringement, which means that if you are found to be infringing other people's patents, it will triple the amount of damages that you are responsible to pay, which makes these patent judgments astronomical. Sometimes they can even reach, there's been multiple lawsuits now where the settlements are for $1 billion. And, that would sink any company that I'm aware of.
Mm-hmm. Yes, by far, easily. So the last one here. A patent stops all infringement automatically.
No, the patent is only one step in preventing infringement. Ideally, you will obtain your patent. Other people will see that you got a patent on your idea, and they will stop any or refrain from doing any activities that would be considered infringing. In reality, some people just don't know that they're infringing, or if they're really bad actors, then they just don't care and they do it on purpose anyway. And so once you have your patent, then you have to enforce it, or you can enforce it if you want. And so enforcement can take a lot of different forms. Sometimes it's cease and desist letters. Sometimes it's, actually filing a patent lawsuit or something along those lines. But yeah, getting a patent grants you the right to prevent others from doing it. But the patent itself doesn't actually prevent other people from doing it. Then you have to go out and enforce it.
Makes sense. So if you're listening to this podcast and you're hearing some of this stuff, or you have made use of these myths, believe me, they're not all right. And I think Mario just proved that, right? So ultimately, I know you can go to milanoip.com and contact Mario. Mario, what are the last tips that you would give to the listeners in terms of patents, in terms of these myths? What would you tell them?
Yeah. So if you hear anything about a patent and you're not sure if it's right, or you want to learn more information, certainly contact your local patent attorney. I'm happy to help, happy to chat. We do offer free initial consultations. So any questions that you might have, I'm happy to help.
All right, everyone. That's Mario, and I'm Craig, and we'll catch you on the next episode of Secure Your Creations. Till next time. Bye-bye
Thanks,
now.
Greg.